Okay, so now we get to the process that the employer must go through if it obtains a background check and wants to act on the results of the background check. So under the Fair Credit Reporting Act, that's the focus here, the federal law. Before taking an adverse employment action, the employer must notify the applicant that an adverse action may be taken, provide the applicant with a copy of the background report that the employer obtained from the Consumer Reporting Agency. And there's also a requirement to provide the applicant with a summary of your rights under the Fair Credit Reporting Act. And that's a document that's produced by the FTC, and that it's available on their website. So typically this is done through what's commonly known as a pre-adverse action letter. That letter will include this information. It will enclose the summary of rights, and that's given to the applicant, letting them know, hey, some stuff came back on your background check. We may take action here. So the employer will provide that to the employee and must give the applicant a reasonable amount of time to respond to that report or to offer any other additional information to the employer. The law isn't exactly clear on what constitutes a reasonable amount of time, but there is federal guidance from the FTC that 5 business days is generally considered reasonable. Of course, there may be circumstances where 5 business days is not reasonable if you need to fill an emergency position, something along the lines of that. But again, generally 5 business days is considered reasonable to allow the applicant to respond. Also consider speaking with the applicant about the report that came back, about what happened, maybe giving the applicant time to talk to you about the incident, when it was, what happened. That may allow you to better determine whether you, the employer, want to take action on that.